there, everybody. We're joined today by Eric Blatt, and we're going to talk about kind of that examination process. What goes on? What do you need to know? And really, what are those next steps whenever that examination occurs? Eric, thank you so much for joining us and being able to give our, let's just call them participants, or kind of our students, since this is going to be online learning, and give them a flavor for that. What is critical to know about examination? Eric, do you want to go ahead and introduce yourself for our audience?
Sure, Dal. It's a pleasure to be here today. So I am a patent attorney, and I'm also a former patent examiner. So I worked at the U.S. Patent and Trademark Office as a patent examiner for about 6 years. I reviewed hundreds, possibly thousands of patent applications in that role. And then I entered private practice. I've done a mix of patent infringement litigation. So I have seen, the full life cycle of the patent. I've seen, how you get through the patent office. I've seen how you litigate. I've seen the discovery, all the arguments, the expert depositions, the briefing, the hearings, all of that. And then, I also continue to draft patent applications, largely for startups and small businesses, although also for some larger companies. And in that capacity, I prosecute them before the patent office. So I go back and forth with the patent examiners and try to persuade the patent examiners to allow my clients' patent applications in sort of the way that makes the patent most useful to the client.
That is an awesome summary, Eric. And, it definitely shows to our audience here why we decided that it was so vital to talk to you, because you have that information kind of from both sides of the examination process. So talking about examination, one of the things that seems like it's that first biggest hurdle for people is actually convincing the prosecutor that what they have is novel, that it's unique, that it's useful, that it's something that should be patented. What are some tips for kind of getting over that first hurdle or crossing that first chasm as people are going, I want to protect my intellectual property?
Sure. So a lot of that starts at the drafting stage. So you will draft your patent application. At the end of that, at the end of the application, the specification, you'll have a section called the claims that will define what you're claiming is your invention, your legal right to exclude others from practicing whatever's in the claims. Then you'll file that. And depending on exactly how you file it, whether you file a request to expedite, whether you have some basis to make it special, and also what art unit, so what technology group it goes into and how busy the examiners are in that art unit, you may wait anywhere between 5 months on the low end and 2 or 3 years on the high end for an examiner to pick it up. And the examiner's job is to do a very thorough review of your application. So the first thing that they'll review will be the claims. That's by far the most important part of your application from the examiner's perspective. And a lot of people are surprised to learn that some of the examiners, as you get more experienced, the examiners really only look at the claims. They might look at the claims, they might do a quick pass through the figures and a very quick pass through the specification. But largely, examiners do not have time to do a detailed review of your specification. They're going to focus on what the claims are and what the claims mean. Then the examiner spends some amount of time searching for prior art, essentially earlier filed patent applications, although they'll also do a Google search and they'll look for non-patent literature, scientific articles, et cetera. And their job is to come up with some sort of basis to reject your patent application. Obviously, they want to get to the right answer, but from the examiner's perspective, they're looking for some sort of reason to reject. And if they are allowing everything they look at, it sort of looks like they're not really doing their job, right? Their job is to find prior art. If you don't find prior art, maybe it means everything you're looking at is patentable, but maybe it means that you're not looking hard enough. Usually, actually, about 80% of the time, the first communication that you get from your patent examiner will be a rejection. And so I always tell my clients that you should expect this, that the first, what you bring to the table, what you file, is your opening offer. And you should expect the patent examiner to come and say, no. Sometimes they say yes, but more of the time they say no, you're going to need to narrow the claims. Then what you want to do is you want to look at it's called an office action, the non-final rejection or an office action. You want to look at that and you want to understand why the examiner has rejected your claims over the prior art that the examiner has cited. So you need to sort of detach yourself from what your invention is in your mind and instead look at the claims, because that's what the examiner is looking at. And you want to look at the references that the examiner has cited. So usually your claim will have sort of a series of elements or little paragraphs, little partial sentences, and the examiner will take each of those blocks of your claim and they'll match it up to a paragraph in the prior art reference that the examiner has cited. So you want to go block by block in your claim and look at block by block, the paragraph by paragraph in the reference the examiner has cited, and see if the examiner is right, that each of those claim blocks is actually in the prior art reference. Usually the examiner will be mostly correct, although often there is one block or two blocks in your claim where the examiner has stretched a little bit, where it really doesn't match up properly. The reference is really disclosing something else. And those are going to be the things you're going to want to focus on in your response. If you have a block in your claim that really doesn't match up to what the reference is talking about, that's a reason that the examiner's rejection might be mistaken. So after you do that analysis, you want to reach a decision on whether the examiner is off base, whether they've cited a reference that's really not pertinent, or whether the examiner really has something that there's a point here, right? Maybe the reference is actually pretty good. If the reference is pretty good, what you need to do is you need to think through the rest of your claims. So you don't usually only have one claim. You might have dependent claims. You look through those and see if there are any that are missing from the reference. And if the other thing you're going to look to is at your specification and your figures to see if there's anything that you can add to the claim to get around the prior art references that the examiner has cited. Then you're going to want to, so either you're going to wind up finding something in the claims as is that's missing, or you're going to find something in your specification that you think you can add to the claims that's missing. And then you'll essentially write a response that says, okay, so in the world where you just keep your claims as is, you say, dear examiner, this is my claim. I understand this is your argument here. However, this part is missing. Please take a look at this. This is really different and it's important because X. And then you file that and you see what the examiner does. If you're going to amend the claims, then what you do, you basically do the same thing and there's a specific way you need to amend it. So get your formatting right. And by the way, the Patent Office has a pro se assistance program. So if anyone is doing this on their own without an attorney, you should Google the Patent Office's pro se assistance program, and they'll help you get all of your formatting correct. But essentially what you'll do is you'll submit your claim amendment, and then you'll also submit the same argument, and you'll highlight that part that you added to the claim. You'll say, this is missing, and it distinguishes the reference because of this.
So it almost sounds like it's similar to the data gathering that they would have had to do to file the application, as they're kind of going line by line, looking at structure, looking at facts, looking at figures, and making that argumentation on, okay, this is correct, or this was misinterpreted, or no, there's some nuance missing here, and here's why that nuance is very important. Now, you talk about emailing kind of back and forth with the examiner. Is email the only way that you can actually kind of just get a hold of an examiner and talk through stuff?
So if I mentioned emailing, I shouldn't have. What you wind up doing is you do written correspondences that are submitted. You write letters, essentially. They're called replies or responses. But you would draft a document, a Microsoft Word document, and then you would submit it through the USPTO's electronic filing system. And the PTO collects all of the correspondence related to the application in one place called a file history or a file wrapper. And so you'd be able to log on and see all the communication related to your application.
So then that kind of static notification is the only way, or can you actually just give them a call?
So yes, you absolutely can. So what you want to do, often it's beneficial to not only go back and forth pushing paper with the examiner, but to have a conversation with them. And the way you do that, so the examiner will will issue an office action and they sign it. And above this, the signature is a conclusion paragraph that provides the examiner's contact information. And it also provides the examiner's supervisor's contact information. So if you do want to have a live discussion with the examiner, often it's a good idea to do that because examiners have very short time to review an application and create a document and an office action. Usually, depending on the seniority of the examiner and the art unit they're in, think 6 to 10 hours, somewhere in that range, in order to review your invention, do the prior art search, and write up this document. And the document, by the way, the office action, they're often 10, 20, or 30 pages long. So the examiners have a limited window, and a lot of times they'll miss things, right? If you want to do a prior art search, you're not going to be able to read every single patent that you review. So having a call can be helpful. So the examiner knows you're a person with an interest here, right? The examiners have a docket of 200, 300, 400 applications just sitting there. If you're just an application number, you're probably going to get a little less attention than if you talk to the examiner. And then having that conversation with the examiner will help them understand what your invention is and also help them understand your arguments better. So it definitely is a good idea to reach out and have a call with the examiner. The time to do that would be after you have reviewed the office action, after you've done that claim to prior art reference mapping, and you understand sort of what the differences are and what the paths ahead might be to move the application forward. Then you would have a call with the examiner and you'd talk through everything.
So it almost sounds like it would be a great idea for someone to have that, not only that information in hand, but to have their kind of idea structured on this is where the differences are, this is where the nuance is, this is why this actually matters. Should someone just kind of start firing that off, or should they lead in with more of a natural, okay, well, I did my own research, this is what I found, this is why I think this is important? Would you recommend that it's more kind of a natural flowing conversation, or since they have such a limited window, should it be really hit them with the facts and then, good speed and God luck?
So I would definitely have a plan for what you want to address it's called an examiner interview. The examiner is supposed to give you up to 30 minutes. And at the end of the 30 minutes, the examiner is allowed to say goodbye. So I would have structure for what you want to say. The way that I personally like to structure my calls with examiners, and by the way, I interview almost all of my applications. Sometimes I conclude that I have a good argument, it's going to be persuasive in writing, and I can just file it. But probably 80 or 90% of the time, I do go ahead and have a call with the examiner early on in the examination process. And the way that I like to structure my examiner interviews, there's sort of 4 points that I want to hit. So obviously, I want to start off by, this is not one of the points, I want to have a friendly introduction, say hello, try to make the examiner recognize that I'm a person and that I care about this and my client cares about this. Then in terms of the structure of what I want to hit, first I want to explain what the invention is. So what did the inventors come up with? Why does this matter to the world? Why is this an improvement? And the way that I'm going to tell the story about the invention is going to be set up to draw a contrast versus the prior art references the examiner has cited. So I'm going to talk about why this is an improvement. I'm going to talk about specific things that are in the invention that are missing from the prior art. Then I'm going to explain to the examiner how I interpret what the prior art teaches. And so again, that's going to be to contrast. So I said the examiner is this, and it's really important that it has this feature A. And then I'm going to talk about what the reference 1 is and why conceptually it's different, but also why it lacks feature A and why that makes the prior art reference 1 worse. And then if there are other references, usually the examiner will wind up combining 1 or 2 or 3 prior art references. And so you'd need to do that with each of them. Then the examiner doesn't just want to hear at a high level why your invention is different than the prior art. They want to also see, so after you summarize your invention and you summarize the prior references, you're going to want to talk about why feature A is important and why it's missing from all of these. Then you need to tie that to the claims. That because again, what the examiner doesn't really care all that much what your invention is. They'll be happy to hear the story. What their job is to look at the claims. So once you've set up that this difference exists and this difference is important, then you need to explain, okay, how is this different actually captured in the claim language? And so in the world where it is captured in the claim language, you point that out and you say, here's block 3 and block 4 of my claim, and this goes after that feature that I just told you is important and is missing from the prior art. In the world where you don't have that claimed and you need to make an amendment to put that in, then what I would usually do is I would first ask the examiner if they agree that this is a difference that's missing from the references. Sometimes they'll say yes, and sometimes they'll say, well, I understand your argument, but if you look at this right here, and other times they'll say, I understand what you're saying, but I would need to review the references in more detail. I can't, study this document to that level on a 30-minute call. And that's perfectly reasonable. And after I get some sort of take from the examiner in terms of whether they agree that this feature is missing, then I would ask the examiner if they have any suggestions for how this can be better recited in the claim to better distinguish the prior references. Usually the examiner will not have any suggestions for you, but sometimes they will. So, and I always find it's helpful to get them thinking about how they can move the application forward toward allowance. And so I usually offer them an opportunity to comment before I make my suggestion. And then finally, I'll make my suggestion. So I always come prepared with my argument and my suggested amendment to better specify this difference that I'm saying is important. And so after I've asked the examiner if they have suggestions, I say, would this be helpful? And hopefully the examiner says yes, but they don't always.
Well, it sounds like it is super valuable then for them, any of the people that are trying to patent their technology that get a rejection to go, okay, let me sit down, let me really think about this, let me kind of strike this out line by line, bullet by bullet, come up with a game plan, and then have that call. It sounds like that call can be super important in helping people move their patents forward and move their protections forward.
It can definitely compress the timeline. So a lot of people, especially folks who haven't filed patent applications before, we're sort of coming in with the expectation that I'm going to submit this and it's either going to be allowed or it's going to be rejected, and we'll just see which one it is. It's not that. It's you initially get rejected and then you negotiate. And that negotiation can, in some cases, hopefully it won't for the people who are watching this call, but that negotiation can take 3 or 4 or 5 or 6 or 7 or 8 back and forth over a period of several years. Yeah. You don't really want that because it winds up becoming expensive in terms of filing fees if you're hiring an attorney. And then additionally, you wind up making all sorts of statements in the file history that wind up being used by anyone who's accused of infringing your patent to narrow the scope of your claim and avoid infringement. So everything you put into this record, if you sue someone for patent infringement or if you ask someone for licensing royalties, they'll go back and they'll look at everything you said in these arguments, and you can wind up saying things that hurt you in litigation. So you really do want to compress that process. Instead of having 8 back and forths, have 1 or 2 or 3. And having that interview up front can bring that number down considerably and make sure that you're on the same page as the examiner and everything you're doing is moving the ball forward.
Oh, that was some really excellent information about that kind of examination process and some tips and tricks there, Eric. We really appreciate you being able to come in and being able to talk to our, let's call it a listening audience / viewing audience here. Is there any final thing or final thought you'd like to leave people with?
I wish everyone the best of luck in terms of getting your patents on file in good shape and in terms of persuading the patent examiners to allow your applications. And I wish you the best of luck with your business strategies. If I can be helpful, please feel free to reach out. If you just Google my name, you'll probably find me on LinkedIn. And I'd be happy to chat with anyone if I can be helpful.
All right. We appreciate it as always, Eric. Thank you for joining us today. And from my side, for our listening audience, we really hope that this was valuable information and that it's really going to help you kind of navigate this oftentimes thorny road on getting your intellectual property protected. Thanks, y'all, for watching, and see us next time for another, hopefully really amazing interview like Eric gave us.
Thanks, Al.
Thank you, Eric.